Welcome to Legal Literacy series. This is my fifth presentation in this series. In my fifth presentation, I am talking about the role of witnesses in criminal law. So as I mentioned in my earlier presentation, I have divided for the purpose of better understanding the criminal procedure code into two parts. One investigation and the other one is the trial. This is the second part of my presentation where I am going to take up the discussion on trial. As I mentioned earlier, every process of establishing of crime passes through two stages: investigation and trial. Investigation is a stage where the police and the experts of crime investigation, they do the whole investigation process. In this process, society or a witness are involved to identify the criminal and explain the stages of the crime. The involvement of society is very important because they establish the whole conduct of the accused or the criminal to prove the intention behind the crime as well as the actual commission of crime. So once the investigation is completed, the charge sheet is filed in the court and we move to the second stage of establishment of a crime, and that second stage is the trial. And in this trial, the police passes the baton to prosecution and the prosecution tries to establish the case beyond a reasonable doubt and get the conviction for the criminal. The trial stage happens in the court, and in this stage also the witness, the society is involved in helping the prosecution as well as the judge to come to a final conclusion and help in justice delivery. This is the second part of criminal procedure code presentation, that is the role of witness during trial. So taking JAGO further from the earlier presentation, JAGO, a witness or an alert citizen or an important person or part of the society, and he can involve in a trial stage at different capacities. As JAGO has informed about the crime, he being the informant, he needs to come to court and explain how he came to know about the crime. Secondly, he being witness to the crime, he need to explain what he had explained at the investigation stage. Same thing needs to be explained before the judge in the open court. And if JAGO is a professional like a doctor, then he need to explain the medical examination and its reporting. We all know JAGO plays a very important role at the trial stage. At the investigation stage, he is the person who has gone to the police station and explained the incident to the police in charge. But now the case has reached the trial stage. It has taken ample of time to reach that stage. So the first task before the court is getting JAGO to the court. How do you get him? So for this process, the court would ask JAGO to appear before them on a particular date, time and place, and most importantly explaining the purpose of his visit to that place. So these four contents are mentioned in a document and it is sent to JAGO, and that is called as summons. Generally for this summons, JAGO, the other witnesses would respond, but it may not happen all. Sometimes the witness don't respond to the summons, then the court go on to take up additional steps to ensure the attendance of the witness. Just I want to put a caveat, a form of explanation that these additional steps are not taken under general circumstances. So you need to understand one thing, that Jago is called to the court to assist the court. If he is coerced to come to the court, then definitely he would be non-cooperative and turn hostile, which would be of no use for the court. So therefore, summons would be the process of the first and the last step for the court to get him. They keep sending summons after summons. Arrest warrant is one additional step where the court thinks that he needs to be arrested by police and brought before the court. But this arrest process is an extreme step, and generally court don't go ahead with this. Bond is another thing, interesting things, where Jago comes after much persuasion and the court is not sure that whether he is going to come back or not. So therefore they ask the witness to furnish a bond in the form of a surety or a security that he would come back. There is a moral obligation created on him that he would come back and attend the court. In addition to these two, there will be another two powers which court enjoys. There is attachment of property, an extreme step, an economic coercion where the property belonging to Jago would be attached by the court, asking him to come and appear and cooperate and then take the property back. Sometimes Jago's presence is required for production of a document or production of an evidence. So there the court may order for search warrant and his house could be searched by the police under the instruction of the court. You all are aware powers that the court enjoy to get the attendance of witness. Here the witness has no option but to come before the court. After coming before the court, what he is expected to do? He is supposed to explain the scene of the crime. One important purpose of his presence in the court would be test of identification parade. You might have seen in newspapers as well as in electronic media that police proudly display the recoveries of stolen property and stand and pose for the photographs, and in front of them there will be 3-4 people squatting who are accused of that stealing of those properties. In 99% of cases, almost 100% of cases, their faces are covered. And why the accused faces are covered? The reason is the test of identification parade. The accused needs to be identified by the witnesses in the open court. If the face is not covered, then the defense, the accused might take a defense in the court that he has seen me in the newspaper. That's how he is identifying me. Otherwise, witness was never present at the scene of crime. So this test of identification parade is an important stage in the criminal proceedings. This stage can be conducted in investigation stage as well as in the trial stage. So witness would be called in the police station as well as in the court for conducting this stage. Sometimes Jago comes before the court, appears, explains, cooperates, and then he is asked to leave, telling him that his requirement is over. Sometimes Jago can be recalled because the charges have been reframed. Take an example that a person is been accused of causing grievous hurt. He has been charged for causing injuries to the body of another person. Jago is examined, his evidence is collected. But later stage, the victim succumbs to the injury. Now the charge is being changed from grievous hurt to murder. So once the charge is changed, the witness needs to be examined again, because earlier his examination was to prove grievous hurt. Now his examination is going to prove the murder. So therefore, witness can be recalled when the charges are altered, added or changed. So another important requirement of witness in the open court is the judge closely observe the witness and see his demeanor and his sweating palms, his behavior, his attempt to avoid eye contact. All these things are observed carefully by the judge to understand the truthfulness behind his statement. Witness has to attend the open court and explain the incident. It's a rule. As the famous saying goes, every rule has an exception. This rule too has an exception. The attendance of witness may not be insisted if it causes a lot of delay for the court, or it involves a lot of cost factor, or it is too much of inconvenient for the person, for the court, as well as for the society. Under these three circumstances, the court may appoint a commission to go to the place where the witness resides and conduct the examination. The commission would conduct the examination on behalf of the court. The only problem with this system is the judge won't be able to observe the witness's mental state while explaining or while answering the questions, because the demeanor noted would not be done by the same judge. This is all about the Criminal Procedure Code role of witness at the trial stage. Thank you for watching.